Hi, welcome everyone. This is Arlene Yang. As we're going to be having a lot of people who are joining us, I'm going to just run through a few housekeeping matters first, and then we'll get started with our presentation. So thanks for joining us. I hope you are safe and dry. We've had amazing, incredible weather over the last couple of weeks. This is the 2023 employment law update for public employers. I wanted to just let you know we have closed captioning. If you wish to turn that off on your end, you can do that or turn it on down at the bottom of your screen if you're on a computer. I wanted to let you know that this presentation is being recorded, but since it's in a webinar, we cannot see or hear you. And we will be circulating a link to a recording of this webinar, as well as the PowerPoint and some more detailed written materials in about a week or so after this presentation. And for those of you who are attorneys, we will also provide MCLE certificates. If you have any questions during the presentation, we'd love to hear them. Please include them in the Q&A function, and we will either address them live or we can follow up with you afterwards. Or I think there's a feature also to respond in writing as well. So please feel free to ask questions along the way. We're here to help. And, but if there are questions that are, especially if there are questions that are very detailed or maybe just related to an individual employer, we will follow up and get back to you. We had over 300 people who responded to register for this webinar, so we certainly won't have an opportunity to answer all questions. We also have Elena, who's here with us, who can help with any technical issues if you're having problems seeing or hearing our presentation. And I just wanted to know, Myers-Nave also, we have a very large public entity practice, but we also serve private employers. And if that's the situation you're in, please come back and register for our webinar that's tomorrow that's focused on issues related to private and nonprofit employers. And with those housekeeping matters out of the way, welcome to Myers-Nave's 2023 Employment Law Update for Public Employers. My name is Arlene Yang. I'm a principal in the Labor and Employment Group down here in San Diego. And as usual, California employers have to be on their toes every year. There are so many new changes to the employment laws, and we're here to help you to make sense of this today. Myers-Nave serves public entities around the state with a range of services, and we help our clients to resolve their most complex and highest priority transaction, litigation, and regulatory compliance issues. I'm specialized in employment law, and that includes advice and counsel, litigation, and internal investigations. And I'm here today with three fabulous attorneys that work with me, and I'll be serving as a moderator, and they'll be presenting most of the materials. So let's start off with introductions for Corinne.
Hi, everyone. My name is Corinne Johnson, and I'm a senior associate here in our San Diego office.
And Alicia.
Hi, everyone. My name is Alicia Morrell, and I am a senior associate in the Oakland office.
And Neha.
Hi, everyone. My name is Neha Shah, and I'm a senior associate in the Oakland office.
And so moving right along, we wanted to learn a little bit more about you as well. We have a little poll question, so hopefully this can, yes, so we can get our poll features. If you could let us know if there's something, if there's an issue that you're most worried about coming up this year, so we can get a little idea. And then while we're waiting, I just wanted to let you know this is intended to be an informational presentation and not advice on any particular legal issues. So if you have a particular legal issue, please contact us or another attorney. And then I guess we'll see what the poll shows once the numbers are in. So if we can move on to the agenda as well, just to let you know kind of what kinds of things, we can go on to the next slide. What kind of things we'll be covering in this presentation today. Some of the key issues are related to pay transparency, the California minimum wage increase, new meal periods and rest periods for public hospital employees and the implications potentially for other public employers down the line. Leave benefits and accommodations issues, looking at bereavement leave issues, paid sick leave, and other changes. We have workplace protections related to discrimination and our continuing COVID compliance efforts, labor relations, and equity in the workplace, including the upcoming 2024 marijuana changes. And we'll have some time for questions at the end, but feel free to jump in the Q&A if you have any questions as we go. So with that, let's go right in. Do we have an answer to our poll? Okay, so new leave laws and labor relations are the top two issues for, thank you very much. If you have other issues, please feel free and let us know as well. Thanks. Now, moving right into our agenda, we start off with Alicia.
So I know you all wanted to talk about new leave laws and labor relations, and we're gonna, but first let's talk about something that you apparently are not that interested in, which is pay transparency. So we do have a couple of new laws regarding pay transparency and some new obligations that we want to make sure that you are keyed into, because they're going to be pretty important. And to the extent that they're new, we don't necessarily know how they're going to play out, but it's possible that there might be some pretty big implications moving forward. So for you all in the public space, the big thing for you to know is that moving forward, and really this is to address things like wage disparity at the beginning of employment, all employers with 15 or more employees need to include wage disclosure, basically information. So there needs to be a pay salary for your job posting. Now this applies to employers with at least one employee based in California. So, you know, you're public, so you've got an HQ in California, but moving forward, and for any of your friends and associates in the private space, if they have a business outside of the state, but have one employee in California, then they apply. Now, what's important for you to know is that this is not just a pay scale that's included on a posting on your website, but also any third party that you might use. So if you post on LinkedIn, if you use Indeed, if, for example, it's an executive position and you're actually using a headhunter, they need to be provided with that pay scale information so that they can include it on all of their postings and advertisements for the position. Additionally, that means that there are some, and let me go back really quickly. So the definition of pay scale is pretty broad, and it's also open to interpretation in some respects. So it's defined as the salary or hourly wage or range that the employer reasonably expects to pay for the position. It also is important for you to know that it does not include bonuses, commissions, health benefits, or paid time off. But if the position is hourly or salary and based off of a piece rate commission, then that piece rate commission range needs to be included. So, and this also is if you are in California, but your employee might be remote. So it's remote or in person. So please make sure that moving forward, that information is something that you're including in your postings. Additionally, for current employees, they have the ability now to request their pay scale for their position, and that is information that you will need to provide for them. So it's quite possible that some of you, given that it is the 11th, maybe you've already received some requests from employees, but maybe not. And if so, or if you haven't, or if you have, that's information that you do need to report. What we don't quite yet know yet is the timeline that you're going to need to present that information. So I would say that this is something that you need to reasonably respond to. Do you have to have it within the hour? Not likely. Do you have to have it within perhaps 5 business days? Quite possibly. Additionally, there is a requirement for you all to retain your records with respect to job title and wage history for every employee for the duration of their employment and for 3 years after. So these records need to be available. So you need to have them. It's not something that you need to create upon request, but it's actually something that you need to create now and maintain for the timeline as their employment and kind of the 3 years after requires, because that needs to be available to the labor commissioner for inspection upon their request to determine if there is perhaps a pattern of wage discrepancy. And I will say that according to the state, your failure to keep those records creates a rebuttable presumption in favor of an employee's claim for wage discrepancy. So you're going to help yourself out by handling these requirements, these record requirements early. So, and there is just a little bit of information to provide for you now about what enforcement looks like. However, because we are quite early on, we haven't seen any enforcement yet, but likely by the end of the year, we will have a little bit more kind of boots on the ground information that we can share with you. But there is a private right of action for injunctive or other relief, and there are also civil penalties. So a person can file a complaint with the labor commissioner within 1 year from the date that they learned of a violation, and there might be civil penalties of up to $10,000. However, with respect to like the requirement that you post the pay scale on any job posting, the first penalty will not be assessed if you demonstrate that you have fixed the job posting by updating it to include the pay scale. But that second time, now we're talking about the potential for civil penalties. So you're going to do yourself a favor by making sure that you've got that information included. As far as key takeaways are concerned, we want to make sure that you all are preparing pay scales for your new positions. Every posting that you do from here on out needs to include that pay scale information. You're going to want to also develop a system to ensure that postings include the pay scale. So perhaps kind of another round of checks and balances, especially right now because it's new. And if that's not been your practice, this might be a new thing for you all. And we're going to want to make sure that you have just taken the step to make sure that you're complying. Additionally, you're going to need to be preparing pay scales for your current positions as your employees may be requesting those. If they never have in the past and you've never had that scale, now is certainly the time to start. Perhaps you've already had that information, and if that's the case, you're already ahead of the game. Additionally, you'll want to create a system to handle how you are going to respond to employee requests for their pay scale information in a timely fashion. So perhaps that means that you have one person who they want to go to for all of those requests, or you just have a system for responding to those. There's no requirement that the system be the same for everyone, but having a system is going to help you stay organized and make sure that you don't accidentally violate these new requirements. Additionally, you will want to have a plan for saving data, especially any of the older data. So you might have an employee who, based on their records and their date of separation, that data might otherwise be purged in a kind of soon. You're going to want to make sure that you have new data retention policies and systems in place with respect to this data specifically, so that you are not running afoul of these new record retention requirements.
We had a couple questions, Alicia.
Hit me.
So we had some questions about what the pay range is. So thinking about when a public employer has to provide the pay range, it would be the range for the position and not each individual step within the range.
I think it's the range at which you reasonably expect to make a hire. So if you are advertising for a senior level 4 position, you would not include the pay range for that first step, for example, because that's not where you expect to make that hire. However, that does mean, kind of depending on the job, that you're going to see some very strange ranges that might have like $100,000 in between. But it's truly what's reasonable for you and where you expect to reasonably make that hire. You're never going to include the pay range for a first-year employee if this is someone for the posting that requires 20 years of experience, for example.
Great, thank you.
Yeah. And that's it for me.
Right, we had one more question. Are you precluded from hiring above or below the posted range?
You know, that's a great question, and I don't necessarily know. My gut says that you're certainly never going to be precluded from hiring above the range. That's a gift that you give to everyone. However, I am not sure about whether or not.
Yeah, I think it has the word reasonable in there. So if so I think that there's some wiggle room to, if there's something that comes up, there might be ability to change, but it would be
It would
safest
give me
to-
pause if
Right.
you had posted a range and the low end was, say, $50,000 and you tried to bring someone in at 35. That might be unreasonable as far as below the posted rate. So reach out to us after this and we'll do a little bit of research for you and get back to you, because that's a great question.
All right, thanks, Alicia. Next, we're going to be moving on to the California minimum wage increase. So if you don't already know, as of January 1st of this year, the California minimum wage increased to $15.50 per hour for all employers, regardless of their size. This increase was required under California law due to inflation. So keep in mind that your local city or county minimum wage may be even higher. For instance, the city of San Jose has increased their minimum wage to $17 per hour, and the city of San Diego has increased its minimum wage to $16.30 per hour. So the takeaway here is to check your local and county minimum wage ordinances and update your minimum wage payments and postings to reflect state and local increases. Next slide. Moving on to public hospital and meal rest breaks. As I'm sure many of you know, prior to this year, all public employees were exempted from California's meal and rest break requirements. As of January 1st, 2023, however, public hospital employees are entitled to meal and rest break periods, similar to their private sector counterparts. This applies to all employees who provide direct patient care or who support direct patient care in a general acute care hospital, clinic, or public health setting, and are employed by the state, counties, and municipalities in California, including the regents of the University of California. So even though this new law does not apply to most public employers, it could be a sign of what is to come for other employers in the future. Applicable workers must now receive an unpaid 30-minute meal period for shifts over 5 hours, which must begin before the end of the 5th hour, and a second unpaid meal period for shifts over 10 hours that must begin before the end of the 10th hour. Employees also must receive a paid 10-minute rest break for every 4 hours or a major fraction thereof worked. If an employer violates this law, employees are entitled to an additional hour of pay at their regular rate of pay for each workday that the employer does not provide a meal or rest break. As with their private employee peers, public hospital employees are now entitled to these breaks, may waive their meal periods or take on-duty meal periods as allowed under existing California law. Employees under a valid collective bargaining agreement, however, if that collective bargaining agreement addresses meal and rest breaks, those employees would be exempt from this requirement. Meal and rest break violation claims is something that we see in almost every wage and hour lawsuit. So if you have public hospital employees, we suggest contacting counsel to fully understand the ins and outs of these new requirements. And now turning to California's new bereavement leave. As of January 1st, 2023, eligible employees are entitled to up to 5 unpaid days of bereavement leave upon the death of a family member. This new law applies to all public employers. Employees are considered eligible if they have been employed by the employer for at least 30 days prior to the start of the leave. A family member means mostly immediate family, so including a spouse, child, parent, sibling, or grandparent. Eligible employees must complete their leave within 3 months of the date of the death, but the days of bereavement leave do not have to be taken consecutively. Leave must be taken pursuant to an existing bereavement leave policy. Next slide, please. If you do not have an existing policy, the bereavement leave may be unpaid. However, employees may use any leave balances available, including accrued sick leave. An employer may request that the employee provide documentation of the death of the family member within 30 days. The term documentation includes things like a death certificate or a published obituary. Employers must maintain employee confidentiality with regards to these documents and shall not disclose them to except to internal personnel or counsel. This law does not apply to an employee who is covered by a valid collective bargaining agreement that provides for bereavement leave. It's also important to note that the new law changes bereavement leave for certain permanent employees of the state. This applies to any permanent employee who is either excluded from the definition of a state employee in section 3513 of the government code, or anyone who is a non-elected officer or employee of the executive branch who is not a member of the civil service. For these permanent state employees, the first 3 days of bereavement leave are to be paid. There is no longer a requirement that the death be out of state for the employee to receive an additional 2 days, and paid leave cannot exceed 3 days. So be sure to update your policies and procedures to comply with the new bereavement leave requirements. And moving on, as of January 1st, 2023, there was a significant change for California employers with respect to family and medical leave and paid sick leave. Employees can now identify a designated person for whom they want to use leave when they request either unpaid leave under the California Family Rights Act, also known as CFRA, or when they request paid sick leave under the Healthy Workplaces, Healthy Families Act, which I will refer to as PSL or paid sick leave. Under both amended laws, employers are able to limit an employee to one designated person per 12-month period. How each of these laws define designated person, however, differs slightly. So let's start with CFRA, which applies to all public employers. And as a reminder, CFRA provides unpaid job protected leave to employees to care for family members who have a serious health condition. CFRA previously defined family member to mean mostly immediate family, including a child, parent, grandparent, sibling, and spouse. Now the family member definition also includes a designated person, which is defined as any individual related by blood or whose association with the employee is the equivalent of a family relationship. Unfortunately, the law does not define equivalent of a family relationship. Like other family members, employers are able to request a healthcare certification for CFRA leave used for an employee's designated person. Next slide. With the ability to take leave for a designated person, all public employers may be required to provide as much as 24 weeks of unpaid leave because of the Federal Family and Medical Leave Act, FMLA, which applies to all public employers. This concept is best explained through an example. So if we have employee Corinne and her brother and maternal aunt each have a serious health condition, Corinne can choose her aunt as her designated person because they are related by blood. So scenario one, Corinne first takes leave to care for her aunt. In this scenario, Corinne could use up to 12 weeks of CFRA leave to care for her aunt as her designated person. Because her aunt is not an FMLA family member, those 12 weeks of leave would not count against Corinne's federal leave entitlement, meaning Corinne could then use up to 12 weeks of FMLA leave to care for her brother. In scenario two, Corinne first takes leave to care for her brother. A sibling is a family member under FMLA. So under this scenario, Corinne's employer could double count that leave under both FMLA and CFRA so that Corinne would be unable to use an additional 12 weeks of leave to care for her aunt during that same 12-month period. Now turning to the paid sick leave definition of a designated person. Under California's paid sick leave, an employee can use sick leave to care for a family member, which previously was defined as the same family members that we reviewed for CFRA. Now this definition includes a designated person who is a person identified by the employee at the time the employee requests paid sick leave. So it's really important to understand that this definition is much broader than the CFRA definition because it does not require the person be related by blood or even have a family equivalent relationship. Subject to guidance from California's Labor Commissioner, a designated person for paid sick leave purposes might include a roommate, a romantic partner, or a friend. See your local or see the handout that we're going to send you after this presentation for information about how this new law might affect local ordinances that provide additional sick leave coverage.
Corinne, we had some questions also about whether there can be templates provided for some of these new policies. So certainly if we're contact us and we can assist you with providing templates for any of these new policies.
Yes, absolutely. And lastly, let's talk about the addition of a designated person, which expands the ability to take kin care leave. So kin care only applies if an employer provides sick leave or paid time off beyond what is required under the paid sick leave law. So under these circumstances, the kin care law requires that an employee be allowed to use up to half of the employee's accrued paid time off to care for a family member. The definition of a family member for kin care is the same as the paid sick leave definition, which now includes a designated person. And again, that definition does not require a blood or family type relationship. So takeaways for designated person leave: review and update your handbook and policies to reflect this new law, and absolutely reach out to us if you'd like us to assist with drafting those policies. And prepare to handle and track the use of these leaves to care for a designated person. And monitor the websites of the Labor Commissioner and the Civil Rights Department, which we'll touch on later, for forthcoming guidance or proposed rules. Also sign up for our client e-alerts, because we will, as information is coming out and guidance, we will send out information to our listservs. All right, now switching gears to a few federal laws. Typically, we don't pay as much attention to federal law because California law is usually more protective of employees than federal law. However, there are two new federal laws that provide additional protections to pregnant employees. First, we have the Pregnant Workers Fairness Act, which will be effective on June 27th of this year. This act constitutes a major shift in employee protections for other states by requiring employers to provide reasonable accommodations for pregnant workers. However, in California, employers were already required to grant reasonable accommodations for pregnancy and childbirth-related conditions through the interactive process if the employee is disabled by her pregnancy. The only change we will see in California is that the federal law applies to quote unquote known limitations, regardless of whether the condition meets the definition of a disability under the ADA. So the act defines known limitations as physical or mental conditions related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. So what might be a new required accommodation? Possibly changing a uniform or dress code, like allowing a pregnant worker to wear maternity pants. An employee might not be disabled by the inability to wear maternity pants, but it would probably be considered a known limitation of pregnancy that a pregnant worker requires maternity pants at some point. The typical interactive process rules still apply, covering things like required documentation and the exception for undue hardship. So the takeaways are HR should be aware of this new federal law, which requires employers to engage in the interactive process regardless of whether the condition meets the definition of a disability. If you have a pregnant worker requesting accommodations and you are unsure whether you are required to provide them, we suggest contacting counsel. And now turning to the other new federal law we're going to talk about, which is the Providing Urgent Maternal Protections for Nursing Mothers Act, or the PUMP Act. This act expands federal workplace protections for employees who need to express milk by requiring employers provide reasonable break time and space. This act will be effective April 28th of this year. And again, California already has the majority of the PUMP Act protections in place. But what is going to be new in California is that employers are going to be required to provide reasonable break time for employees to express milk who give birth to a stillborn child or a child over whom the employee does not retain legal custody. Employees will be entitled to, reasonable break time for expressing milk will be considered hours worked if the employee is not completely relieved from duty during the entirety of the break. And an employee must inform the employer of the failure to provide an adequate place to express milk and give the employer 10 days to come into compliance before bringing an action against the employer. Please see your handout that we'll send out after the presentation for an explanation of the laws already in place in California regarding employees who need to express milk. And now I will turn it back to Alicia.
All right, let's talk about a couple of different areas where we have new or increased workplace protections. So starting off, the Sexual Abuse and Cover-Up Accountability Act is not specific to the workplace, but there are some implications. So we wanted to make sure to go over that with you today. So this act provides additional time for victims of sexual abuse to pursue legal claims by lengthening the statute of limitations in two circumstances. One, claims of adult sexual abuse that occurred after January 1st of 2009, and the claims commenced after January 1st, 2019, that would have been prohibited only because of that 10-year statute of limitations, are now timely if they're filed by December 31st of 2026. So that greatly expands that statute of limitations. Additionally, damages suffered because of a cover-up of sexual assault that occurred on or after the victim's 18th birthday are also have an extended statute of limitations, and that covers related claims. If the claim would have otherwise been barred because of the statute of limitations, which would have expired before January 1st of this year, those claims can now be brought this year in 2023. And truly what we're telling you this for, as far as takeaways, is that employers, you all now need to know that it's pretty imperative that you review any non-disclosure agreements or confidentiality agreements that you have to make sure that they include language specifically stating that confidentiality provisions do not prevent an employee from discussing the underlying facts of a sexual assault in the workplace. And if we can go to the next slide, I think that's where the takeaways are, please. Additionally, this is an opportunity for you to remind and train folks in the workplace, especially supervisors and HR staff, that you're going to want to avoid any practices that would incentivize silence surrounding claims of sexual assault in the workplace. And then as a reminder, always promptly investigate any complaint of sexual assault or harassment in the workplace and ensure that accurate records are being made and kept appropriately. I think all of us within labor and employment at Myers-Nave, and specifically those of us that you see on screen today, all do work within investigations, and to the extent that you need some assistance or would like to discuss sexual assault in the workplace, sexual harassment in the workplace, or investigations related to those, please make sure that you reach out, because while we do not love that for you, we would love to assist you in those moments. So now let's shift to talking about COVID. So there is a new COVID exposure notice requirement. The notice requirement that existed beforehand was set to expire at the end of 2022 and has now been extended to 2023. The notice requirement, however, looks a little bit different in the workplace than it used to. So now, when you receive notice of a possible workplace exposure through a positive employee, you'll need to place a notice in all of the places in your workplace where you normally post notices for employees, and it needs to state the following: the dates that that employee who tested positive was on the work site, and that's only within the infectious period. You don't have to post the entire dates of their employment, but just when you know that they were likely at the workplace while potentially positive and infectious. Additionally, the location of the potential exposure, and that needs to be posted with specificity, including the department, the floor, the building, or the area if you have a workplace that's kind of spread out, because people need to be able to understand with a little bit of clarity where the exposure might have happened to see if they're potentially impacted. Additionally, you'll need to include contact information for who they can talk to about COVID-related benefits. So that's likely someone in human resources, but whoever that person is for you, their contact information will need to be included in the posting. And then you'll also need to include information about the CDC cleaning and disinfection plan and Cal OSHA's prevention program. That posting has to go up within 1 business day of the employer receiving notice and has to stay up for at least 15 calendar days. So that is the timing requirement. So it is something that you have to jump on pretty quickly after you are informed of a potential exposure because a person has communicated to you that they have tested positive. Additionally, you can still provide written notice to employees. So I think many of us are used to individual emails that they might have received, either that there was a general exposure within the workplace or that you were a close contact. You can still send those communications if you'd like, especially with respect to the close contact. However, you are required to do this new posting in this new way. Additionally, if you have a employee portal on like an intranet where you do postings regularly, you can also use that as a method for posting. However, what you cannot do is create a new portal for this. So basically, we're kind of bringing the postings into how your employees normally receive information so that they have the best likelihood of seeing it. So that is the case with the new notice requirement. Additionally, when we're thinking about COVID, there is a little bit to discuss, not much, with respect to workers' compensation. So through 2022, there has been a rebuttable presumption that under certain circumstances, COVID-19 related illness was presumed to be work-related for the purposes of awarding workers' compensation benefits. So not all the time. And of course, if you had an employee who's been working from home and hasn't been in the workplace and then comes down with COVID, there is no rebuttable presumption that it was related to work if they weren't outside of the home or doing work things outside of the house. However, there were some situations in which that rebuttable presumption existed. Those presumptions were set to expire on January 1st of this year, and as it stands right now, are extended through to January 1st of 2024. Additionally, this extension of workers' compensation benefits brought into the fold a number of active firefighters who are now going to be considered under the first responder and healthcare worker categories. And those are active firefighters for a number of departments at state agencies such as the Department of State Hospitals, Veterans Affairs, and the Military Department. Ultimately, here the takeaway is that HR staff needs to keep in mind that COVID may still be compensable under workers' comp, and please encourage your employees to report workplace injuries and infections.
Hi, Alicia. We have a bunch of questions. I don't know.
Oh my gosh.
We're running a bit behind, so I don't know if we'll have time to answer them all, but we have a number of questions related to email notification of COVID and posting versus email. So I think there's a lot of details. I don't know if you have any thoughts on that initially, or we can just follow up after the presentation.
What I will say generally, and we can follow up, please reach out, and yeah, we'd love to talk about it, but what I will say generally is that it is required that you comply with this new posting requirement. It is a very good business practice and a good idea that you continue to individually communicate to your workplace via email if there has been kind of a generalized exposure, and to directly communicate to any person who is likely the recipient of a close contact exposure because of interaction within a defined space with someone who has tested positive. And some of that is the same as it was last year, and some of it is new, but please make sure that you are meeting this new posting requirement at the very minimum. However, I think, for me at least, erring on the side of more information is better is probably going to save the day. Additionally, when we're thinking about COVID, there is and actually, you know what? This isn't even about COVID. We're now shifting into a space of Cal OSHA kind of generally. So California employers may not take adverse action or threaten to take adverse action against employees who refuse to go to work or stay at work due to due to a reasonable belief that the workplace is unsafe due to an emergency condition. However, emergency condition, kind of vague. So for the purposes of this new regulation, an emergency condition refers to conditions of disaster or extreme peril to the safety of persons or property at the workplace or worksite caused by natural forces or a criminal act. It also refers to an order to evacuate the workplace, a worksite, or a worker's home, or the school of a worker's child due to a natural disaster or criminal act. Additionally, an employer cannot prevent employees from using their cell phones or mobile devices to seek assistance or information or to communicate with others, such as family, in an emergency condition. So 2 important things for you to keep in mind with respect to this. One, this is a reasonable person standard. So the belief has to be reasonable under the circumstances that there is a real danger of death or serious injury if that person either enters or stays on the premises. And when we're thinking about reasonable, you do get to apply a little bit of common sense. So for example, a worker can't stay home due to impending wildfires that are 150 miles away. That's not reasonable as far as an impending peril. Additionally, like you couldn't go home early from your job in California if there was a tsunami warning in Hawaii. That is not reasonable. The other thing for you to know is that this regulation does not apply to health pandemics such as COVID. There is additionally a very long list of workers that this regulation does not apply to, such as first responders, residential care facility workers, disaster service workers, and the handout that you'll receive after this will include that list. So please make sure to cross-reference who the regulation does not apply to versus your types of employers. And then ultimately, you may need to establish or update your emergency plan and policies with respect to the requirements of this regulation. So then last up for me, with respect to COVID, or excuse me, with respect to Cal OSHA, is that there is a new non-emergency regulation that is not yet official, but is set to be voted on this month. And then it will take effect for 2 years. And there will be a record-keeping obligation within some of the sections that will be in place for 3 years. Some highlights include that employers still must provide face coverings and ensure that they are worn when the Department of Public Health requires. Some of the same things like making sure that COVID testing is available at no cost during paid time for employees after a close contact. There are some additional new obligations, such as making sure that your ventilation in your buildings is compliant with respect to basically the prevention of COVID and airborne illnesses. What I think is really important for you all to know is that employers are no longer required to maintain a standalone COVID prevention plan. Instead, rather, you should have COVID addressed as a workplace hazard under the requirements found in state regulations regarding your injury and illness prevention programs. Now, this includes hazard prevention training, outlining what your organization's plans are to prevent transmission and investigate or respond to workplace exposures to COVID. Obviously, I will tell you that helping you with your IIPP is something that we can certainly do, especially because many of you have employees who are now either most recently or will be in 2023 returning to the workplace. It's probably a good idea to just revisit that document in general, but also making sure that you're including those COVID prevention plans within the document. So if that is something that you are looking to do at the beginning of the year, please reach out. We'd be happy to help you tidy that program and that document up. So I am now going to turn it over to Neha.
Great, thank you, Alicia. So let's talk about labor relations. Everyone seems to be really excited about that on this call. Effective September 2022, SB 931 allows unions to file a claim against an employer before the Public Employment Relations Board, also known as PERB, where they can allege violations of Government Code 3550. And Government Code 3550 prohibits a public employer from deterring or discouraging public employees or applicants from becoming or remaining union members. This government code is often referred to by its acronym PED. Similar to SB 270, which was passed in 2021, the passage of SB 931 marks the expansion of penalties for public employers at PERB. A violation of PED subjects the employer to civil penalties of up to $1,000 per affected employee, not to exceed $100,000. Additionally, SB 931 gives PERB the authority to award attorney's fees and costs to the prevailing union. PERB will consider several factors when assessing a civil penalty amount, including the employer's annual budget, the severity of the violation, and any prior history of violations by the employer. Just note the test for reviewing violations of PED is objective, meaning it doesn't require a showing that an employee was actually deterred or discouraged. The big takeaway for employers is that there is a potential for significant penalties against an employer who engages in impermissible anti-union activities. So this, coupled with the fact that there are only a few cases interpreting the legislation or identifying activities that constitute a violation, mean that employers really need to tread with caution when assessing what constitutes deterrence or discouragement. Next slide, please. In Teamsters Local 2010 versus the Regents of the University of California, PERB actually provided guidance to public employers as to what types of mass communications under Government Code 3553 could also be considered a violation of PED. Specifically, what types of mass communications could be considered deterrence or discouragement by a public employer. In this case, PERB found that the Regents violated Government Code 3553 and PED by distributing several sets of frequently asked questions to employees in a specific classification that were recently added to an existing Teamsters bargaining unit. The communications included information about union membership and union dues. PERB found a violation because the university did not first provide the Teamsters with an opportunity to meet and confer over the communications, because the university distributed the FAQs, and the FAQs in and of itself tended to influence employee free choice regarding joining or supporting the Teamsters, and that the university provided no business necessity for distributing the FAQs without first meeting and conferring. In their decision, PERB stated that any mass communication addressing the general subject matter of union membership or dues is a communication concerning a public employee's rights to join or support an employee organization, or to refrain from joining or supporting an employee organization. And that even if it's a neutral communication, it has the ability to influence employee free choice and therefore violate PED. The big takeaway for employers is that even if it's a seemingly innocuous communication or neutral communication, it may still have the ability to influence employee free choice and therefore create liability under PED. So it's important that you work with your counsel if you are planning to make any mass communication regarding union membership, and also to ensure that any meet and confer obligations are satisfied. Next slide, please. So in this case, the U.S. District Court for the Eastern District of California provided guidance to employers on when an elected official's public statements lose protection. In Fitzgerald versus City of Fresno, Plaintiff Fitzgerald was a police officer for the City of Fresno. And upon learning about his membership in the hate group, the Proud Boys, the city terminated him pursuant to the municipal code. The day after his termination, the mayor of Fresno published a public statement on his Twitter page, which mentioned the ongoing investigation into the officer's affiliation with the Proud Boys. And it stated, "It is clear to me that there was an egregious violation of department policy. I will not tolerate any form of racism displayed by City of Fresno employees. Fitzgerald's termination proceeded without the opportunity for him to review materials upon which his termination was based, and without actually allowing him the opportunity to respond to the charges against him. Fitzgerald then filed suit claiming libel and that he was deprived of liberty without due process. Specifically, he argued that he was stigmatized as a racist. The court determined that the mayor's Twitter statements were not protected as to the information shared because it was obtained from Fitzgerald's personnel file and from the ongoing internal investigation, which was confidential. Further, the court determined that the mayor's Twitter statement expressed an opinion that implied an assertion of fact that the officer is racist. The court explained that while the civil code confers privilege status upon statements made by public officials, the reach of that privilege is limited. So the privilege protects any statement by a public official as long as it's made, one, while exercising policymaking functions, and two, is within the scope of his or her official duties. So this is also known as the official duty privilege. A public official cannot be said to be properly discharging their duties when they violate a statute by publishing confidential material. And if a public official knew or should have known that the publication of confidential material violated constitutional or statutory law when they published it, then they could not be said to be properly discharging their official duties. So the big takeaways for public employers are that statements by elected officials can create liability for defamation claims against the agencies if the statements violate confidentiality laws or are considered false statements that cause harm. Agencies should make sure their elected officials are trained on confidentiality obligations, including employee privacy under the Constitution and Brown Act closed session proceedings. And you should definitely confer with your Myers-Navet counsel prior to, or if you need assistance in reviewing a public statement. Next slide, please. So generally speaking, in California, prior to dismissing or disciplining a permanent state employee, the employer must give the employee notice of the reasons for the proposed discipline, the penalty for a sustained action, and give the employee an opportunity to respond. And this is usually contained in what's referred to as a notice of adverse action, or at the municipal level, a notice of intent. So in this case, in Rogers versus State Personnel Board, the California Court of Appeals addressed what constitutes sufficient notice and a notice of adverse action when there are multiple allegations alleged, but not are all ultimately sustained. In this case, Plaintiff Rogers was employed with the Department of Corrections and Rehabilitation. He was served with a notice of adverse action alleging that he refused to perform a required restraint check at the beginning of his shift, that he directed officers to falsify his records, saying that they had performed the checks, and that when he found out that he had been reported, he angrily confronted his colleagues and used profanity. So the department informed Rogers that they would be reducing his salary by 10% for 2 years, and he appealed the discipline to the State Personnel Board. The ALJ found that Rogers had not refused to complete his duties, he had not directed anyone to falsify records, and that although he had angrily confronted his colleagues and used profanity, he did it because he felt wrongly accused. But nonetheless, the ALJ found that the use of his profanity violated the law and upheld the entire reduction of his salary. Rogers appealed the decision, arguing that the notice was insufficient to put him on notice that he could receive the entire penalty, even if only one of the 3 allegations were sustained. The Court of Appeals agreed with him and said that because the ALJ had found that Rogers had engaged in significantly different conduct than what was identified in his notice, Rogers lacked such notice that his conduct would subject him to the full salary reduction. The court explained that the question is not whether misconduct occurred, but rather whether the employee was on notice that the employee's specific conduct could subject them to the proposed penalty. So the big takeaway for employers is that when you are preparing a notice of adverse action or a notice of intent that contains multiple allegations of misconduct. Employers should clarify within the notice whether the proposed discipline would be enforced even if only one of the multiple allegations are substantiated. And if you are unsure about how to draft the notice, you should consult with counsel. Next slide, please. Okay, let's move on to equity in the workplace. And this is more of a heads up. Effective July 1st, 2022, the California Department of Fair Employment and Housing, also referred to as the DFEH, was renamed to the California Civil Rights Department. So this is not a new government agency. The Civil Rights Department operates under the direction of an executive officer known as the Director of Civil Rights. And the Civil Rights Department still reflects all the same existing powers and authorities of the DFEH. The rename was more to fully capture the services that the department provides and hopefully increase public access to its services. So a couple takeaways are that you should ensure that you have updated versions of Civil Rights Department's required posters, guides, and fact sheets to reflect the new name, logo, and the website. And also you should review and update any handbooks and or policies that make reference to the DFEH. Moving on to marijuana use. So currently, employers can effectively prohibit marijuana use on and off the job. However, beginning January 1st, 2024, AB 2188 will create anti-discrimination protections for employees who use marijuana off duty and away from the workplace. SB 2188 establishes a new category of employee protection under the California's Fair Employment and Housing Act, also known as FEHA. Once effective, employers will not be permitted to discriminate against employees based on their use of marijuana off the job and away from the workplace, or based on employer-required drug screenings that find non-psychoactive cannabis metabolites in the employee's hair, blood, urine, or other bodily fluid. The new protections apply to persons through hiring, termination, or any term or condition of employment. Employers can still enforce drug and alcohol-free workplace policies and may still test current employees if there is an individualized, reasonable suspicion of impairment on the job. It's important to note that this legislation does not apply to employees in building or construction trades, and employment or applicants or employees hired for positions requiring federal government background investigation or security clearance. Department of Transportation drug testing requirements still apply to certain safety-sensitive transportation employees. So there are several big takeaways for employers in relation to this legislation. Namely, employers should update their drug and alcohol-free workplace policies to be compliant with AB 2188. This includes a policy specifically forbidding on-duty use of marijuana and also defining what it means to be off the job and away from the workplace, which might have changed because we're in this remote hybrid world now. And if necessary and applicable, consider a separate and detailed Department of Transportation drug and alcohol testing policy. Your policies should set clear standards for when a reasonable suspicion exists to conduct drug tests and who makes that decision. And this is really crucial for reducing an employee's reasonable expectation of privacy in the workplace. You may also need to reconsider the types of tests used to test marijuana impairment. Many blood and urine tests measure non-psychoactive marijuana chemicals that do not reflect current impairment and instead reveal only whether an employee has consumed marijuana over an extended period of time. So you should coordinate with your testing provider to discuss what testing options are available and compliant with this legislation. And at this time, we are aware of breathalyzer tests that might be available that will test only for a certain THC metabolite that would be compliant with this legislation. Additionally, if you are in a unionized workplace, employers should notice the unions and engage in required bargaining as soon as possible. Notice might not just be for implementation of a compliant drug-free workplace policy, but also to the extent that changes need to be made to MOUs or collective bargaining agreements, such as provisions related to callback or standby emergency policies, you would still need to notice the union. And just a reminder, you do have a full year to comply, so there's no need to stress yet. We do have an employment law alert that's being released later this month with more detailed information about it, but you can always reach out to us too, and we'd be happy to assist you with policies or related negotiations.
Great. Thank you so much, Neha. So unfortunately, we are right at 1 o'clock now. So we have a number of questions about off-duty marijuana use. And if you left us with your name, we will follow up with you and look to stay on the alert for the e-alert. But thank you all for joining us. Feel free to reach out with us with any additional questions, and our contact information, if we can just forward a few slides, our contact information is available here as well. So thank you so much, and we will see you soon.